I applied to every justice.
Oh, okay.
I applied to every justice. Justice Breyer was the one who interviewed me. So yeah, I didn't think it was likely that I would be an ideal candidate for some of the justices, but I was, again, very happy, obviously, to work with Justice Breyer.
How many clerks were there with Breyer?
So there were 4 of us total at the time, yeah. And since he was the junior justice at the time, he had to take notes on what everyone said, and he always spoke last since he was the junior justice at the time. So then he would come back to our chambers, to his chambers, and he would sit with us and he would go through each case and say, okay, here's what Tony said, you know, and here's what the chief said, and here's what I think. And so in that sense, we would actually be the first clerks to know most likely what happened, because he had such detailed notes of everything that went on at the conference. And then he would give us a 2-sentence or so description of if he wanted to write an opinion or if he was assigned to write an opinion, 2-sentence description of what he thought the opinion should look like, and then everyone would go to work.
At the end of the conference, when he comes back and has his briefing with the 4 of you, would he know at the end of the conference whether he was going to write an opinion?
He'd have a pretty good idea. I mean, he wouldn't. There were certain cases, I'm sure, where he. Were
they assigned at that time? After they took their sort of.
My recollection is that they were assigned at the conference. Okay. Yeah, that's my recollection. And so he would have a sense that if he was writing a majority opinion, he'd have a pretty good sense of that. And then if he wasn't, he wouldn't be sure if he was writing a concurring opinion until he would see the majority. Right. But he might think, oh, Justice Scalia is going to run with this. Maybe, I mean, I agree with the outcome, but I would like to write an opinion that says something slightly different. Maybe that would happen too. He might know that at the conference. He wouldn't, and he'd probably know if he was going to write a dissent at that point too. My experience of it was write a draft, give him the draft, and then he would sort of sit and write his own draft with his draft, with my draft maybe right next to him while he's writing, and then he'd hand his draft to me and he'd say, yeah, there were some things in your draft that I might not have put in here, but that doesn't mean they shouldn't go in here. And there were some things in my draft that maybe weren't in your draft. That doesn't mean they should be in here. And so we'd go back and forth and back and forth. I mean, he has a very particular voice, and he also sees, I think, the law in a very particular way. And so, our role was to do some of the work to get him to the point where he's got a final opinion. It's hard to know when you get to the end of the final opinion how much you contributed to it and how much of it is all the justice. I mean, it's usually a mix, at least in terms of the rhetoric and certainly in terms of the law that gets cited. But I never had an experience where Justice Breyer said, okay, this is the opinion that you get to write and I'll just do a light editing job. I don't think that's in the justice's nature. So the opinion is circulated to everyone once there's a draft that the justice is comfortable circulating. And then basically justices will send notes to Justice Breyer, and maybe a justice will send a note as simple as, I join. Or maybe a justice will say, I would join if you would make these suggestions or make these changes to the draft. Or someone would say, I can't join, I'm going to be circulating a dissent soon. That's basically how it worked. And of course, on our side, it was the same way. I mean, Bush versus Gore was, of course, on a much shorter timetable. But certainly all the opinions were circulated, and so there was certainly opportunity for people to decide whether to join or not, whether to dissent or not. I think that given the short timetable, people had a pretty clear idea of whether they were going to dissent or not. But yeah, of course, the same exact procedure.
In that case, was it a committee rather than an individual clerk involved?
Well, for us, because again of the short time frame, we all participated in working on the opinion that ultimately the justice signed. I don't know how it worked in other chambers. I assume that given the exigencies that was probably the same thing. It was an awful lot of law to get through, an awful lot of argument to get through, and to do it in the time that we had, it would have been pretty hard for one clerk and the justice to do on their own.
Back to Bush versus Gore. If that was presented to the court today, would it be a different decision?
I don't know. You know, I think with Bush versus Gore, I agree with Justice Breyer's ultimate take in his opinion, which was that the mistake was basically to take the case, that it was not a case that the court should have heard. You know, when one thinks about the equal protection portion of Bush versus Gore, if that were applied in every context, we would have a very different equal protection clause. Mm-hmm. So, you know, if the question is, would that equal protection principle be upheld today? I don't think so. But is the question in that if we were faced with a very, very similar factual circumstance, would we have the same outcome? I don't know. I think it probably depends on whether or not the court has learned from Bush versus Gore, right? Whether or not they've learned that it was a mistake to take it or not. I mean, one thing that's clear is that I don't know that there's been any Supreme Court opinion that cited Bush versus Gore. I mean, I don't know if there's any opinion in the history of the Supreme Court that's been cited less by that institution than Bush versus Gore. I don't know if it's been cited in any majority opinion. It may have been, maybe it's been cited in one dissent. I don't even know if it has. So that tells a story about sort of the worth of that opinion, I think. But
did you get a sense of the history of it all when you were in the middle of it?
I got a sense that it was historic. I mean, I tell people sometimes that it was like being in the middle of a natural disaster. You know it's historic, but it's not. So I got the sense that it was historic, and whatever way it came down, I got the sense that it was historic because we were taking this case that seemed unusual for us to take, and also, of course, it was historic because it involved a presidential election. Had it involved a congressional election or even an election for the Senate, it would have probably felt less significant. In fact, it would have been less significant. So I didn't I didn't have any sense for how history would judge the opinion.
Right.
No, I think I talked to some clerks who would defend the opinion and probably would defend it today. And certainly there were some clerks who would never defend it. So I don't think one could generalize about what the clerks thought about it.
Did you take a poll? Did you know?
No, I did not take a poll.
Did you get a sense that these judges, though, shared with their clerks their thinking?
Oh, I think so. Yeah. Oh, I think most of them had a pretty open line of communication with their clerks. I mean, the clerks played different roles in different chambers, but in terms of talking about the cases, I think most of the clerks had a pretty good idea of where their justices were coming from on all of the cases. I considered it an accomplishment if in a discussion with Justice Breyer in which I was trying to convince him of a position that he was not inclined to take, if I could get him to take his hand off the doorknob before leaving the room. That's what I considered an accomplishment, if he could turn around just to hear me out, right?
Has it given you a special cachet to have been a law clerk for a justice of the Supreme Court?
Well, I think it does give a special cachet. I mean, I think that I try to resist that it means anything other than the fact that I had an opportunity to learn from a tremendously intelligent justice and also be surrounded by really intelligent clerks. I think it's made a difference in my career in terms of as a lawyer. I think it's made a difference in my career. I think it's made me a more effective lawyer. I think it's made me a more effective writer. I think it's given me opportunities that I wouldn't otherwise have had. I don't know if that's a good thing or a bad thing. So it gives a cachet. But, I think one always has to be cognizant of the fact that there are 1,000 other people who could have had that job and done a great job doing it. And for whatever reason, I was fortunate enough to get it. But I don't think that makes me special because I had that opportunity. It's what I do with the opportunity that's more meaningful.